You know that gas tank that might be in your kitchen? What if it was a total fake? We're about to dive into a wild legal showdown that took this super common household item and turned it into a massive Supreme Court case. And trust me, this story isn't just about gas. It's about brand piracy, who's really responsible when things go wrong, and the promises that big companies make to every single one of us. So the entire conflict really boils down to this one picture. On one side, you've got the real deal, the official product. It's filled, sealed, and guaranteed by brands you know, like Petron and Shell. But on the other side, you've got a counterfeit. It's the same branded tank, but it's been refilled illegally by someone else. You have absolutely no idea what's really inside, what the quality is, or if it's even safe to use. This is the exact issue that kicked off a legal war that went on for years. So who are the main characters in this corporate drama? Well, in one corner, you've got the heavyweights, Petron and Philippines Shell. They own the famous GASUL and SHELLANE trademarks. And in the other corner, you have a smaller outfit, MASAGANA Gas Corporation, run by the Yao family. They're the ones accused of essentially hijacking those big, trusted brand names for their own profit. Here's the game plan for how we're going to break this all down. We're going to start with the undercover investigation that first cracked this case wide open. Then we'll walk through the three major legal challenges that Masagana's owners tried to use to get out of trouble. And finally, we'll land on the Supreme Court's final decisive ruling. Right, so this whole thing started with a covert operation. Petron and Shell's lawyers had a hunch that something shady was going on. So they called in the big guns, the National Bureau of Investigation, the NBI, to go undercover and see what was really happening inside the Masagana refilling plant. And man, things moved fast. The formal complaint landed on February 11th. Just 2 days later, 2 days, an NBI agent was already inside the plant making a test buy. A couple of weeks later, they did it again, just to be sure. By the beginning of April, they were so confident in what they'd found, they went straight to a judge to get search warrants for a full-on raid. And this right here, this quote from Agent Rich Oblanca's official affidavit was the smoking gun. He didn't just say he saw a couple of suspicious tanks. No, he used the word stockpiles, plural, stockpiles of Shell and Petron cylinders just sitting there. This first-hand account became the absolute backbone of the NBI's case to get those warrants. So when the NBI finally stormed the place, they found exactly what they were looking for. I mean, they seized over 100 official SHELLANE and GASUL tanks, some filled, some empty. They even found tanks where someone had tried to scratch off or damage the logos. But here's the kicker. They also seized the equipment, the refilling machine and the motor compressor, the very tools used to commit the crime. Okay, so with their stuff seized and a criminal case on the horizon, Masagana's owners decided to fight back. Their first move was to try and tear down the whole investigation. They basically argued that the raid was illegal from the start, claiming there was never enough solid evidence, or what the law calls probable cause, to even issue the warrants. And that really is the core question, right? Did the NBI actually have enough solid proof? The Yao family argued that no, they didn't. They claimed the agents were lying, that the evidence was just flimsy hearsay. So let's see how that argument actually played out. Now, before we go any further, let's just quickly define this key legal term, probable cause. It sounds complicated, but it's not. It's just the standard for getting a warrant. It doesn't mean you have to prove someone is guilty beyond a shadow of a doubt. It just means you have to show enough facts to convince a reasonable person that, yeah, a crime was probably committed here. So the Yao's lawyers tried to get clever. They said because the NBI agent used a fake name on the receipt, he didn't have personal knowledge. The court pretty much laughed this out. They said, yeah. Using an alias is a totally standard, completely reasonable thing to do in undercover work. Since the agents were the ones who literally made the purchases, the evidence was direct, it was strong, and that was that. Challenge number 1, down in flames. All right, so plan A, attacking the evidence, was a total bust. So Masagana's lawyers switched gears. Their next strategy? Forget the evidence, let's attack the warrants themselves. They started picking apart the paperwork, hoping to find some technical error that would make the whole search illegal. They basically threw 3 arguments at the wall to see what would stick. First, they claimed the NBI agent wasn't from the right division. The court's response? Irrelevant. No law says he had to be. Second, they argued that Masagana compound was too vague for a huge property. The court said nope, since the whole compound was used by the company, it's specific enough. And third, they complained that the warrants didn't list the exact sizes of the gas tanks. And again, the court ruled that the description was as specific as it could be.
So challenge number 2, also a complete failure.
So, with the evidence holding up and the warrants declared valid, the petitioners pulled out one last, frankly desperate argument. They tried to say, okay, maybe a crime happened, but you can't blame us. Blame the corporation. Yeah, you heard that right. Their argument was that all that seized machinery belonged to MASAGANA Gas Corporation, which, legally speaking, is its own separate person. They, the Yaos, were just the officers. They were trying to build a legal firewall between themselves as people and the illegal actions of the company they owned and ran every day. But the courts have a very powerful tool for situations exactly like this. It's a legal concept with a fantastic name, piercing the veil of corporate fiction. And what it means is that a court can essentially say, we're going to ignore the legal separation between a company and its owners when that separation is being used to pull a fast one, to protect fraud, or to defend a crime. The court's reasoning here was just beautifully simple and powerful. Step 1. A corporation is normally its own thing. Got it. Step 2. But you can't use that legal idea as a get-out-of-jail-free card when you're committing crimes. Step 3. The evidence clearly shows the petitioners were using their company to break the law. So, Step 4. The court can pierce that veil, and poof, that legal firewall comes crashing down. They are one and the same, and they are responsible. So after systematically taking apart all 3 of the petitioners' main arguments, the Supreme Court was finally ready to issue its ruling. And this decision was a big deal. It was going to set a major precedent for trademark law and corporate responsibility for years to come. And the final result was absolutely decisive. How many of the petitioners' arguments did the Supreme Court end up agreeing with? A big fat 0. The petition was completely denied. The court backed up the lower courts, they validated the evidence, they validated the warrants, and they confirmed the personal liability of the company officers. Now, this ruling happened back in 2007, but its impact is arguably more relevant today than ever before. So why should we care about this old battle over gas tanks? What are the big takeaways for all of us? Well, there are 4 huge lessons here. First, brand protection is incredibly serious. Trademarks aren't just logos, they're valuable, legally protected assets. Second, company bosses are on the hook. You can't just hide behind a corporate name to break the law. Third, and this is so important, consumer safety is paramount. That's a huge reason these laws even exist. And finally, it proves that good, solid police work, including undercover tactics, is a valid and essential tool for justice. And this whole thing leaves us with one last massive question to think about. This case was about LPG tanks, right? But the principle applies to, well, everything. From the food we eat, to the cars we drive, to the medicine we take. How many products do you use every single day based on pure trust in a brand name? This story is a powerful reminder of why that trust is so worth fighting for, and the real danger we all face when it gets broken.